Everyone. I'm sure, I think that all of our witnesses thankfully are here in person. We don't have anyone on Zoom, so thank you for being here in person. I'm just going to say a few reminders, although I think all of you are quite seasoned witnesses. Kindly wait until I recognize you by name before speaking. All comments are addressed through the chair. And I'll give you a 1-minute warning, and then basically your time is off once it is completed. And so now I would like to warmly welcome our witnesses for our second panel. We have Professor Michael Barutunsky. How do you say it? Barutunsky. Welcome. We have Mario Bellissimo, lawyer, certified specialist from Bellissimo Law Group Professional Corporation. Welcome. And we have Azadeh Tamjidi, senior legal officer for the United Nations High Commissioner for Refugees. Warm welcome to all three of you. Each one of you will have 5 minutes to give opening remarks, after which we will delve into questions. Barutunsky, thank you. Next we have Mr. Bellissimo, 5 minutes.
Madam Chair, members of the committee, thank you for the opportunity to appear again today. Bill C-12, in my view, presents a meaningful opportunity to modernize Canada's immigration and refugee system while restoring balance, security, efficiency, and fairness. Its aims, integrity, transparency, and modernization are commendable, and measures such as removing the designated country of origin regime, expanding digital tools, and improving cross-agency cooperation are positive and long overdue. The committee, though, has received, as my co-panelists just mentioned, substantial testimony warning that certain provisions expand discretion without adequate safeguards, weakening parliamentary oversight, including the role of this committee. Undefined public interest cancellation powers are of particular concern. The 2012 federal skilled worker termination demonstrated the uncertainty such authorities can generate. The minister testified that public interest is deliberately undefined to preserve flexibility. And no doubt flexibility has value, but without limits, extraordinary powers risk becoming unconstitutional. Similar concerns arise with the ineligibility bars over delayed or trauma-affected claims. There's concerns with the expanded data sharing authorities and with provisions preventing proceedings unless claimants or persons concerned are physically in Canada. We recommend, as set out in our brief and the brief we put before CQ, that those provisions require further study. Now, even if ultimately upheld, implementing these clauses would require major operational changes. For example, many refugee failed claimants, apart from those from moratorium countries, to list one exception, the only remaining pathway would be the PRA, as we've heard. And it's a process not at present designed to replace IRB adjudication. To even approach fairness, PRA would require significant scaling, an independent unit, specialized training, and enhanced protection. The committee may wish to ask IRCC to produce current PRA volumes and processing times to evaluate whether the system could realistically absorb that shift. Recent actions have lowered intake, but Bill C-12's eligibility bars, in our view, will not produce lasting volume change, nor will broad cancellation powers. Canada has seen this cycle before. We've tried restrictive levers and short-term fixes only to see pressures reappear in different forms. The good news is that none of this is inevitable. Lasting modernization and security are achieved not through episodic cancellations or deterrence, but through transparent, predictable intake management across the entire immigration and refugee system. A flexible expression of interest framework could better align admissions with processing capacity and real-time reporting guided by labor market needs and absorptive indicators, including housing, healthcare, and francophone integration supported by modern digital tools. Even in rights-based streams, family humanitarian EOI principles can help not as selection tools, but to manage intake fairly and prevent backlogs. For refugees overseas, a more structured pre-registration process supplementing current UNHCR referrals would enable earlier identification of at-risk populations and orderly, data-informed movement planning and reduce reliance on dangerous, irregular routes. For those already in Canada, the IRB could adopt an EOI-style management national scheduling model supported by C-12's improved information sharing to link hearings to capacity throughout Canada and better identify vulnerable claimants more effectively, reducing adjournments and delays while improving fairness. Our recommendations offer practical ways to advance modernization while avoiding new legal or operational risks. Certain provisions are not suited to quick amendment in our view. To give full effect to the bill's aims, the committee may wish to recommend that complementary reforms reported and already explored here at CIM be referred back for further study and broad consultation following CQ's review. With thoughtful revision that builds on the positive elements of Bill C-12, the legislation can modernize the system in a way that strengthens border security, protects fundamental rights, and enhances public confidence. Canada can achieve both security and fairness without compromise. Thank you, Madam Chair. I look forward to your questions.
Thank you, Mr. Bellissimo. You should be a politician. That's almost exactly 5 minutes. Okay, next we have...
Certainly. And Mr. Bellissimo, you mentioned that, I believe you mentioned that PRA wasn't designed for the way how we're using it right now or intending to use it right now. Do you have any suggestions on how, do you like these suggestions you heard just now in order to adapt it to the way in which we're trying to use it in this new system under C-12?
So I think there's a couple of things there. One, we have to be careful we're not overcorrecting for a temporary intake. So refugee intake is down. The overall volume in Canada is down because of the measures the government has already taken. So the measures that my colleague is suggesting would go towards charter compliance. But in my view, you already have an expert tribunal that is performing those functions. And for the most part, if, as we talked about, with better management principles, better identifying of vulnerable claimants, and some of now the enhancements that Bill C-12 hands the IRB, no need to reinvent the wheel. Leave it where it is, because that's where I think we will achieve the greatest efficiencies.
Better management. You speak about better management techniques with the existing system. Do you want to concretely outline what those are?
So I think Bill C-12 creates an informational journey now that is much stronger than what exists. So what the IRB is going to be receiving is stronger. If you leverage those expression of interest principles we talked about, the intake, the capacity management based on scheduling, no matter where a member might be in Canada, okay, you get that hearing going. You better identify vulnerable claimants so you triage those cases faster. And on the flip side, the cases that are weaker, you triage them out faster. I think with those tools, with what C-12 has equipped potentially, and again, I know the details will be in the regulations, but it sounds encouraging, I think you might see quite a positive outcome that I think CIM should recommend that be seen and not overcorrect on a PRA system that you'll have to scale, you'll have to train officers, you have to create an independent unit. In my view, quite expensive, and you might create a larger backlog, and PRAs are already taking a long time. So if you're now going to place that administrative burden or capacity burden on PRA, I think we're working backwards.
30 seconds.
Now, Mr. Bellissimo, if I have time, very quickly. With C-12, won't we create a bottleneck at the Refugee Commission?
I think it is an overcorrection, and despite debating minimum or gold standards, ultimately you're taking legal and operational risks at a time when the federal court is incredibly backlogged. To me, it's an inopportune time to test something like this. I think it's best to talk about the efficiencies, and you already see all of the unintended consequences, moratorium countries, people in removal orders that'll now need to go for stays while they're waiting for, or to go to a PRA. So in my view, there are other ways to gate it based on the recommendations we made. No need to get into constitutional quagmires right now. Let's stay focused on processing efficiencies using the great parts of Bill 12 to move this all forward.
Thank you, Mr. Bellissimo. Merci, Monsieur Brunel.
Thank you, Mr. Brunel-Duceppe.
Time. I think you know. Thank you. Thank you so much. I want to say a huge thanks to our three witnesses. Not only did you provide important testimony today, but I think very thoughtful and excellent recommendations, which will be taken into consideration. So thanks to all three of you. And apologies, with my last name, you would think I would say everybody's last name perfectly, but I'm as bad as everybody else. So I want to say thanks to all of you. But before, colleagues, hold on, just two quick things just to mention. Our last day for the study is going to be on Thursday. We are officials coming back for the first hour. Second hour is we are going to be looking at the recommendations. And we do have approval to extend up to half an hour. So we do have translation and everything set up. Peter, Mr. Fredriscatos, if you could just wait. I'm just finishing up for Thursday. And then just to let everybody know, next Tuesday we are scheduled to go back to the massive immigration study that we have. Just wanted to make sure everybody's on the same track for that. So with that, nothing else on our agenda. We are adjourned. Yeah, if we don't need it, we don't have to.